Have you ever faced a hurdle in your immigration journey, perhaps a visa denial, and wondered if there was still a path forward? It can feel disheartening, but there are often solutions designed to help you overcome these challenges. A visa waiver is essentially official permission from the United States government that allows someone to enter the country or adjust their immigration status, even if they have been found inadmissible. It's like being granted an exception to a rule that would otherwise prevent you from reaching your immigration goals. The core reason a waiver is needed is to overcome what is called a ground of inadmissibility. This means that an individual has a specific legal factor in their past or present that makes them ineligible for a visa or entry into the United States. Common grounds can include unlawful presence in the U.S., certain criminal convictions, past misrepresentations to immigration officials, or even health-related issues. The specific requirements for a waiver depend heavily on the reason for your inadmissibility and whether you are seeking an immigrant or a non-immigrant visa. For immigrant visas, meaning you intend to live permanently in the U.S., a waiver often requires you to demonstrate what is known as extreme hardship. This means showing that your qualifying United States citizen or lawful permanent resident family member would suffer exceptionally unusual and severe difficulty if you were denied entry. This isn't just everyday inconvenience. It requires compelling evidence of significant medical, financial, or emotional burdens. For non-immigrant visas, where you intend to visit temporarily, the government weighs the positive factors of your request against the negative factors of your inadmissibility, considering why you need to enter and the risk you might pose. To apply for a waiver, you typically need to file a specific form, such as Form I-601, Application for Waiver of Grounds of Inadmissibility, or Form I-212, Application for Permission to Reapply for Admission into the United States after deportation or removal. The most crucial part of this process is compiling robust supporting documentation and a compelling argument. This includes gathering personal statements, letters from family members, medical records, financial documents, and any other evidence that strongly supports your eligibility and addresses the specific ground of inadmissibility you face. It is important to remember that visa waivers are discretionary. This means that even if you meet all the technical requirements, the government still has the final say in approving your request. They conduct a careful review, applying a balancing test for non-immigrant waivers or assessing the degree of extreme hardship for immigrant waivers. Understanding these precise standards and presenting your case clearly and thoroughly can make a tremendous difference. With careful preparation and the right evidence, you can present the strongest possible case to overcome those barriers and move forward on your immigration journey.